So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human
Today we're going
capital
to be answering
revolution.
Ask HR questions from the subreddit Ask HR, as well as from legal advice. I find these questions to be really enlightening, especially for people who aren't familiar with the HR world and want to be protected and understand their responsibilities under the employment law in the United States. And of course, all this is not legal advice. This is just my own opinions of what should happen. So we'll start off with a question about laid off from California. They say the letter only mentions termination. They were laid off and got a separation letter that has no verbiage of a layoff, but only termination. While I am getting a severance, this is also not noted in the letter. Should I ask HR for one that clearly states the layoff? Thanks in advance. Now, one thing that I want to note, so California is lauded for employment rights, and they're quite frequently, that this is really where it's at for an employee. But actually, for example, the state of Tennessee requires you to write clearly that it's a layoff, and you're supposed to give that within, I believe, 1 day of the employee's termination period. So and that's any termination, a quit, a layoff, etc. And so I think that's really interesting that California doesn't require that. But beyond that, no, you don't need to ask for one that clearly states layoff. It doesn't really matter. It's not important. And frankly, if you include a severance in there, it should be quite clear. The only time that it might matter is if you're applying for unemployment. But even then, in theory at least, the company has no standing and really won't matter. So that's why Tennessee does it, is for unemployment. It requires that notice to be given, and that's why Tennessee does it. However, certainly don't go back. I mean, you can ask them because it just doesn't matter at this point. You're not employed there, so you're welcome to, but there's not really any point to doing it. The next one is from legal advice, and the question is discrimination at work, attorney or not. They had a meeting with the EEOC, emailed the first draft of the charge, and wondering if they actually need an attorney. They emailed an employment attorney, but the attorney said that they need to wait for EEOC to rule in their favor. Uh, and it says it makes me wonder why I need them at all if they don't want to be involved until after the EEOC rules in my favor. Well, so the question is, so I'm just wondering if I need one, or can I survive mediation with the employer and the EEOC? Honestly, it wouldn't be the worst idea to have the attorney help with the charge itself and with kind of articulating your issue, but that would be on a fee basis and it would be quite expensive. What the employment attorney is waiting for is the right to sue, which is what the EEOC gives. They're not, being picky or something of that nature. That's the nature of an EEOC charge. The employment attorneys don't get involved until they get a notice of the right to sue from the EEOC. And that's why he made that decision. Well, that's why the attorney made that decision. And so as a result, yeah, you need an attorney after you get the right to sue. Now, I would probably use one to be coached, if I were you, by the attorney to make sure that the EEOC is capturing the actual discrimination. But beyond that, I'm not sure that there's any value until it's found in your favor. So the answer is no, I wouldn't survive mediation with just the employer and the EEOC. I think that's not a smooth move, but it is reasonable that an employment attorney would wait. That's normal. The next one up is kind of interesting. It's a business owner trying to make policies, maybe never having worked in a real business, not sure. Can an hourly employee be locked out for the day for showing up 1 minute late? Hello. My work has decided to enforce a new policy, and I'd just like to make sure it's valid. Starting the first of each month, showing up even 1 minute past the scheduled time will have one warning with no consequence. If it happens a second time, you get locked out for an hour, no pay. If it happens a third time, you get locked out for the day, no pay. The fourth time will require a meeting with the owners before returning to work. Just wanting to make sure this is entirely legal. I don't really know why it wouldn't be. For one, I mean, business owners can decide whether or not you should be there, and if you're late, it is what it is. But I think this is a terrible policy, right? For one, you still are out that work that you need. What you would do is you would do a discipline. You'd write them up, for the first time with a verbal warning, a second time with a written warning, etc., until termination. The idea that you're quote, locked out for a day it doesn't really make sense. You're not getting that work, which is tough. Although, people might not show up if they know they're going to be 1 minute late. They may just not show up for the day and then also take that hit. But regardless, it's just a silly policy. It's a bad one, but it's likely legal in most states, even including California. This is state dependent advice specifically surrounding this, but it's more than likely legal for most of the United States. Let me know what you think about this policy in the comments down below. Is this a good policy? What do you think? I would say no. I think this is, from an HR perspective, this is one of the worst policies I've ever seen. Let me know in the comments down below. Like, share, and subscribe, and I'll see you on the next video. Bye, guys.